So, sir, can you tell us the implication of today's judgment?
Well,
What's the first?
yes, we took an interlocutory appeal today in respect of our request to have access to the data that were used in the conduct of the election. As it were, the Supreme Court appeared in their judgment to have agreed with what the Court of Appeal did, i.e., in saying that we have not given sufficient reasons to have INEC to let us have access into the data that they have at their back end. This data, according to our belief, contains vital information that will assist us to further prosecute our petition. But the good side of it is that we expected something like this could happen. It's either you get your relief or you don't get your relief, so you must have a backup position. Our backup position is what we have done in the Court of Appeal, and the matter is still on. It's at address stage. As far as we are concerned, we are not in any way hindered, and the Supreme Court has given the decision. We're bound by it, but that does not mean that we are not going to prove our case. The truth of it is that we're going back to the Court of Appeal, and then we'll be able to justify our petition. We're undaunted. Any road that you're applying through might be rough initially, but it leads to victory. That's our belief. Thank you.
You know, in the interest of fair hearing, the court will be reluctant to prejudge a matter that is substantive in the case upon an interlocutory proceeding. And that's what they did today. You recall that at the Court of Appeal, the application that cranked up this appeal was that the appellants wanted the server, they wanted to inspect a server which the first respondent INEC said did not exist. You know, and was a major part of the case. So the Court of Appeal said, look, following this long line of cases and the tradition of our jurisprudence, that to grant that order will be like saying beforehand that the server which has been contested to exists. You know, so dissatisfied with that, the appellant came here. And today, the Supreme Court affirmed that principle and said, look, the Court of Appeal was right to have restrained itself from going into that issue upon an interlocutory proceeding. So, I think the decision, I mean, I'm humble enough to say that the Supreme Court is quite correct. What it merely did was to affirm a tradition that this country in our jurisprudence have come to hold as a pillar of our litigation process.
So, sir, for the benefit of our viewers, are you saying that this judgment is a start?
Just your reaction on the Supreme Court's position on your appeal.
We thank Almighty God, and like I've always said, without the Supreme Court, politicians would have since destroyed this country. We are grateful to God.
So it therefore means that there's no server according to INEC.
Look, the issue is, INEC has never said it has no server, but they quoted a particular server. Facts don't lie. Nigeria.com. And INEC says, I don't have that type of server. They even quoted the number of the server. We say we don't have. The judgment today has vindicated us.
So, sir, are you saying that there is a particular server which you have that the PDP they are not aware of?
Look, well, they are not telling us they are not aware of anything. They are saying that there is a particular server which they created and gave it a number. And we say we don't have that server. Well, we have said it time without number. You say I have a white wife. I say I don't have white wife.
That's the end of the